reported in 2017 EKLR. The first petitioner also prayed for costs. Now I go to the second petitioner's submissions. The second petitioner relied on comprehensive written submissions dated the 15th of August 2019. Regarding the plea of res judicata, he submitted that the issues in the instant suit have never been litigated before any other court. The second petitioner's case was that the new currency was not legal tender because of breach of Article 3.1, 10, 19.1, 21, 47.1, and 231.4 of the Constitution of Kenya, and sections 24A, 1F, and 22.1 of the Central Bank of Kenya Act, and sections 2, 3, 4, 5, 6, 7, and 8, and also 11 of the SIA, section 5 of the Access to Information Act 2016, and sections 5, 6, 8, and 12 of the Public Service Values and Principles Act number 1A of 2015. The second petitioner also censored the process for failure by the first respondent to publish its decision by a notice in the Kenya Gazette as mandated by section 2, 4A, 1F, and 22.1 of the CPK Act. He said that the first respondent purported to use legal notice number 231 of 7th December 2018, notice in respect of coins, and legal notice number 72 of 31st May 2019, which notice was in respect of notes to issue the new currency. He argued that the impugned notices only described the technical features of the coins and notes to be issued at a later date. He further argued that Gazette Notice number 4849, issued by the second respondent on 31st May 2019, withdrawing the Kenya shillings 1,000 notes, was the only Gazette Notice that was published. It was the second petitioner's case that the requisite Gazette Notice to circulate the new notes has never been published by the first respondent in breach of section 2, 4A, 1F, and 22.1 of the CPK Act. He further contended that while legal notice number 72 and the Gazette Notice number 4849 were circulated online and later published by the government printer, the one relating to coins, legal notice number 235 of 2018, was only circulated online but not published by the government printer. He maintained that failure to publish the said notice in the government printer is a violation of Article 35(3) of the Constitution, which places an obligation on the state to publish important information affecting the nation. He added that the failure was in breach of Article 47(1) that requires administrative action to be fair, expeditious, efficient, lawful, reasonable, and procedurally fair. The second respondent also took issue with the failure by the first respondent. Sorry, that is the second petitioner. Also took issue with the failure by the first respondent to table the instruments to Parliament as required by section 11(1), 2, and 4 of the SIA. The second respondent further faulted the new currency for bearing sculpture portrait of President Mzee Jomo Kenyatta in contravention of Article 231(4) of the Constitution. He equally questioned the names and signatures of individuals appearing on the face of the notes. He was also of the view that the pictures of unnamed individuals on the reverse of the new 200 Kenya shillings 200 notes offended the law. The second petitioner posited that the portraits reinforces the falsified and highly embellished association of the history of the Republic with the person and the family of the founding father of the nation. He also said that the signatures and names on the currency portray individuals contrary to the law. The second petitioner took issue with the prominence of the statue on the notes when viewed against the KICC tower. He said the KICC has not been gazetted as a national monument. The second petitioner also challenged the legal opinion provided by the first respondent by the third respondent, dated the 30th of October 2013, or in the manner in which it was interpreted by the first respondent. In his view, the opinion ran counter to the spirit of Article 156(4)(a) and Article 156(6) of the Constitution of Kenya. The petitioner, that is the second petitioner, referred the court to Merriam-Webster Online Dictionary, which defines portraits as follows: a pictorial representation of a person, usually showing the face, sculptured figure, bust. A graphic portrayal in words. It further defines portraiture as the making of portraits. He also referred to Bert Gash Nesick, who defined portraits as follows: portraits are works of art that record the likeness of humans or animals that are alive or have been alive. The word portraiture is used to describe this category of art. The purpose of a portrait is to commemorate an image of someone for the future. It can be done with painting, photography, sculpture, or almost any other medium. The second petitioner challenged the withdrawal of the Kenya shillings 1,000 notes for want of a regulatory impact statement required under Part 3 of the SIA. He contended that the deadline was irrational and unreasonable. He said that the withdrawal has led to unnecessary costs and inconvenience to the public. He argued further that it contravened Article 24 and 40 of the Constitution. He also submitted that the petitioner's rights to legitimate expectation were violated. The second petitioner argued that there was no public participation in the impugned decision of the first respondent, in contravention of Article 10 and Article 2321D, which require that the people be involved in policy-making processes. He relied on Kenya Union of Domestic Hotels and Education Allied Workers, Kudheya Workers versus Salaries and Remuneration Commission, High Court, petition number 294 of 2013, reported in 2014 EKLR. He also made reference to a document issued by the Public Service Commission giving guidelines on public participation in policy formulation. The second petitioner submitted that the second respondent should be held personally liable for the impugned decisions and actions and be surcharged for the loss occasioned to the taxpayer. Reliance was further placed on Republic versus Ministry of Finance and another ex parte Nyong'o, Nairobi High Court miscellaneous civil application number 1078 of 2007, reported in 2007 Kenya Law Report 2, page 299, and also 2007 EKLR, where the court held as follows: good public administration requires a proper consideration of the public interest. There is considerable public interest in empowering the public to participate in the issue. It ought to be the core business of any responsible government to empower the people, because the government holds power in trust for the people. People's participation will result in advancement of the public interest. Good public administration requires a proper consideration of legitimate interests, quote unquote. He referred to Public versus Independent Electoral and Boundaries Commission, Expert National Super Alliance, NASA Kenya, and 6 others. Judicial Review, Miscellaneous Application number 628 of 2017, reported in 2017 EKLR, where it was held that public participation plays a crucial role in legislative policy as well